this looks like a motion for possession judgment. Is that correct, Ms. Moore?
Yes, Your Honor.
Could you tell me what it is that you want me to do and why?
Get his name off the title because he's only paid two payments of March 2nd, 2026 at $200, and then April 3rd, 2026 at $250. And it's a $500,000 loan, and I'm the only one paying it. 5,000, I mean.
Good, because there's a $500,000 is an awful lot of money. So where is the vehicle now?
I have it, Your Honor.
In his possession.
Mr. May, why is she making payments on a vehicle that you have?
It was a gift, Your Honor.
She gave you a $5,000 truck.
When we were in a relationship.
That didn't answer my question. You're trying to tell me that she gave you a $5,000 truck that she had to make payments on.
Yes.
Then why did you make two payments on it?
I was working and I got laid off, and I was in a tight spot, and I wasn't able to pay it at that time. And
if it's a gift, why would you want to pay it?
But she was harassing me.
You're giving me other answers than what I'm asking for. You told me it was a gift, so I'm following up on whether or not it was a gift. That has nothing to do with her harassing you. You said it was a gift. If it's a gift, why did you make two payments?
She was asking me for money.
But it's a gift, so why would you make two payments on it?
Because she was harassing me.
Harassment and gifts don't go together. You understand that, right?
Yes, Your Honor.
Who's talking to you?
Nobody, Your Honor.
I'm listening to them whisper to you twice now.
It was my mom over there.
Well, then don't lie to me and tell me nobody's there. So is this a gift or is this harassment?
It was a gift.
Do you have some proof of that?
I do not.
Anybody else that can testify it was a gift?
My mom.
Who's the one that's been whispering to you about what to say?
No, Your Honor.
Are you in a relationship with Ms. Moore right now?
I am not.
How long were you in a relationship with Ms. Moore?
About a year.
And when in that year did she give you this truck?
Last May.
How long into the relationship was that?
That's like 6 months.
So she gives you a truck when you're in a relationship and you leave the relationship and you think that you can take the truck with you?
I was working and I got laid off. I had a lot going on while we were dating, and I just had a lot going on in the relationship, and I just needed to break things off with her because I just had a lot going on, trying to find different jobs, and I was just dealing with a lot.
What does the fact that you had a lot going on have to do with you taking a truck when it was part of the relationship?
I was living at home.
So?
And she had her own place, and I was trying to get
just because you need
work.
Something doesn't mean you get to take something. Tell me why you took the truck when it was supposedly a gift during the relationship.
we were together. My name's on the title.
Great. You gonna start making the payments?
Yes.
Why haven't you so far?
Well, the other day she told me don't worry about making the payments, and I didn't know what to do. I had money aside for the truck, and then I had court, so I was just trying to figure out what was going on.
So you don't have any problem with her request to get her name off the title, right?
Yes.
Ms. Moore, who's the loan through?
Forefront Bank.
Have you talked to them about what they want
Yes,
to do with this?
they told me I needed to get a court order for his name. Well, they sent me to the Secretary of State, and the Secretary of State told me to get his name off the title since he basically ain't paying the payments. And I have asked him in the past to help because it was not a gift. He had asked me to get him the truck so he can get back and forth to work, and he was supposed to pay the payments.
Ms. Moore, you're winning. You don't need to argue it. So if I give you an order that says that the name comes off the title, you're still going to owe the loan, Ms. Moore.
Yes.
Is his name on the loan?
No.
That's a problem. Is it the credit union that you got it through? What's the name of the bank that you got it through?
Forefront Credit Union.
All right. Do you know if they will, in essence, refinance the loan so that he's on the loan and you're not?
I did try calling to see if they could do that, and they can't. And
even if I give you what you're asking for, you still owe the loan. That's a separate document from the title. Is there a secure thing through the credit union on the in other words, can they repossess the truck? You know, if
yes, if I don't pay the payments, yes.
You understand what that means, Mr. May? Mr. May, are you still there? You're on mute, sir.
Yes, I understand.
So how much money do you have to pay on this truck, Mr. May?
I have about $1,800 set aside right now.
It would seem to me to be a very good idea for the two of you to get together and go to Forefront Credit Union and for Mr. May to make a large payment and then begin to make the payments on this until it's paid off.
Your Honor.
How much money is still owed, more?
I owe $2,268.57. That's why I just want to take over the payments, and I want the truck.
Your Honor.
Yep.
Did you get all the paperwork that I sent you?
I got some exhibits from you. I got bills or estimates
That's
of
all.
Doing repair work on it.
Yes, Your Honor.
Okay, so what is that going to have to do with anything?
Is that going to be taken out of my payments?
Nope.
Okay.
Why would it be?
Because I paid it.
Do you think if you took it to the bank that they would say, don't worry about paying us, go ahead and pay the repair company?
No, Your Honor.
Well, then why are you asking me to do that?
I was just wondering.
How old are you, sir?
27.
You ever taken a loan out on a vehicle before?
No.
Here's what we're going to do. Ms. Moore, you're going to make an appointment at the credit union with Mr. May. You're both going to show up together. Mr. May, you're going to bring in your $1,800 and you're going to make a payment on it.
Yes, Your Honor.
Ms. Moore?
Yes, Your Honor.
Now, let me think about it. How much money have you paid down on this truck already?
Over $3,000.
Why did you put his name on the title?
Because we were in a relationship and I loved him.
So what you did, in essence, is let him use it for the amount of time that he's had it. It doesn't make it yours. You've effectively allowed him to use it to the extent that he used it in what you weren't able to, right? For the last how many months has he been gone that you have not had the truck?
Since we got it, Your Honor, in May.
So a whole year now. And his name being on the title means that he's a part owner. So
Yes.
you've got a disagreement as to who owes money on it, but his name's on the title, so he's by law presumed to be a part owner. So I can't just make him give the truck back to you. If he wants to pay for it, he might owe you some more. The two of you might need to reach an agreement, but somebody's got to buy somebody out. You both can't use the truck at the same time, right? You both understand that?
Yes, Your Honor.
So you guys are going to have to get together and work out a deal. If you can't do that, ultimately I'll decide it, but I don't think either one of you is going to like what I decide. So work out a deal. Who's going to pay who? It's a $5,000 truck. Were there some repairs made on it? Yeah, that means it might be worth less if you sell it now, but it's still got some value to it. Only one of you can have it. There's a debt on it. That needs to be paid. If Ms. Moore is not going to have the truck, she should not be paying on it. On the other hand, she hasn't used it at all, so she's owed some money on it. So you guys are going to have to work it out. And the credit union's not going to take her name off of it just because you assume making the payments. She's on the catch for it until it's fully paid off. So we're going to come back here in a little over 30 days, and you guys are going to tell me how you want to work this out. So June 15th. It's a Monday at 1:30. Via Zoom. Do either of you have any questions right now?
No, Your Honor.
No, Your Honor.
All right. We'll send out notices to both of you June 15th at 1:30 via Zoom. I'm hoping that you can reach an agreement before then. If you do, you may need to meet together at the credit union and make whatever payments you need to make to catch the payments up, or maybe to pay it off totally, and then decide how you're going to pay one or the other to get the title in one person's name. And then you can both go to the Secretary of State and agree to put it in one person's name, and then you're done. You don't have to worry about anything. You can call the court and say, we're done. I don't need anything more. If you can't reach an agreement, you'll need to show up in June. Does that make sense to both of you?
Yes, Your Honor.
All right. I'll see you in June. Thank you.
Thanks.
Thanks.
I am Elizabeth Altman, representing myself.
Deborah Altman, representing myself.
Thank you. I don't know that we have two Altman's being sued here. Plaintiff's counsel, who's actually, is it both of them?
Yes, we have two defendants, Elizabeth Altman and Deborah Altman.
All right, I just didn't see the second name in the caption. I guess I do see it on this document. I was just looking at the wrong one, apparently. All right, thank you. We have a garnishment done by plaintiffs, an objection to the garnishment from defendants, an answer in response to that, looks like, and then a follow-up response. As to the original garnishment, counsel, you want to make any arguments that you have as to the garnishment and then any response to their objection?
Yes, Your Honor, the wage garnishment was properly served pursuant to Michigan court rule. Under the court rules and on the face of the garnishment itself, the garnishment is filed with the court and then served on the employer, and it's the employer that serves a copy of the garnishment on the defendants, not the plaintiff. And pursuant to the disclosure, the employer did serve a copy of the garnishment on the defendant. So the proper procedure was followed at all points in this garnishment. Judgment was entered in this matter in July 5th of 2022 by order granting motion for summary disposition on the merits of the case. There's been no payments on this account in the last 6 years, except for a $43.27 payment that came in on February 17th. So as all Michigan court rules were complied with in the service of this garnishment, we ask that the defendant's objection to the garnishment be denied and that the garnishment continue.
All right, thank you. Which of the Altmans wishes to go first?
I will speak to this, Your Honor. This is Deborah. I am co-signer on the loan, and Elizabeth and I have been working together on this. Her wages are significantly reduced. I mean, her hours, and we have tried faithfully since 2022. We have initiated contact with the plaintiff and their attorney via their attorney, and the last communication with them was in 2022 until 3 years later. We received a settlement offer. That was 3 years later. We don't understand why it took 3 years for that to happen. We could have easily had this resolved in 2022. And it's not that we don't dispute that it is owed. We would just like to work with the plaintiff and their attorney to get either a settlement offer again resolved, or installment payments for Elizabeth. We have acted in good faith, and just don't understand why after 3 years now they have just not seemed to be willing to work with us. We are willing to pay on this, just however her wages, I mean, she's already paying on another judgment that is a significantly higher judgment, and the plaintiff and attorney agreed to those payments. She has been making them faithfully and would do so on this. So we just plead the court to consider installment payments for Elizabeth.
What are you suggesting by way of an installment payment?
Sir, at this time, she could afford $10 a month.
What is the outstanding balance on the bill?
The current
Yes.
balance is $2,851.38.
$10 a month is $120 a year. That would take you 25 years to pay that off. Does that sound to you to be a reasonable monthly payment, Ms. Altman? Ms. Altman?
Yes, Your Honor. We She is currently making a $25 a month installment payment on the previous judgment. And I think if that were calculated, it probably would work out to be the same thing. We probably could go up to $25 a month. But just ask that we maybe be given time to work with the plaintiff and their attorney to work this out. Your Honor, I am not showing you. There.
You and I have a different viewpoint about what is reasonable. Even at $25 a month, it's going to take you 9.5 years to pay this off. And again, I'm not here to negotiate for either side. The only issue is the garnishment inappropriate? So if you want to reach an agreement with counsel, feel free to do so. I brought it up simply so he would know what the issue is or what the offer is, but I can't make him take that offer. I can't make him make an agreement with you, just like I can't make you make an agreement with him. They're entitled to their money. They already have a judgment. The only question is, how are they going to collect it? You've raised a couple of different issues. One is service of process. Counsel has responded to that, indicating that garnishments are to be served on the garnishee, that is the place where the money is at, and then that place serves you. And that appears to be done in this case, and the court file has within it a proof of service from EEC Hospitality LLC, which is where your payroll comes from, indicating that you and your daughter were served on January the 20th of 2026. So it appears that proper service was made, so that's not a valid objection to the garnishment. The next one, I believe, is that there was a statute of limitations violation. You said it's been a long time. The judgment was in July of 22. The garnishment was in December of 25, so 3 years at most, and there's a 6-year statute of limitations. So I don't see that being an appropriate reason to not enforce the garnishment as well. The third issue that you've raised was hardship, financial hardship exemption. In your last response to the garnishment, to their response to your objection, you attached, I believe, a copy of the federal rules on garnishment. Code of Federal Regulations, section 34.24. I don't know that this has anything to do with federal garnishment. Counsel, are you aware of any federally related aspect of this case?
No, the federal rules are not relevant to a state district court.
And it appears to me that under the appropriate rules in Michigan, which would be the court rule, MCR 3.101, garnishment after judgment, that the objections to that are limited by subparagraph A. Says that objections may only, this is K subparagraph 1, objections may only be based on defects in or the invalidity of the garnishment proceeding itself or the balance provided on the statement. And then subparagraph 2 says objections shall be based on one or more of the following, and it lists A sub A through G. Under subparagraph 1, I don't find that there's any defect in or the invalidity of the garnishment proceeding. I haven't heard anyone object to the balance, so I don't find any proper objection there. And subparagraph 2, A through G, talks about funds being exempt from garnishment, bankruptcies, barred by an installment payment order. There's a request for that, but there hasn't been any order entered yet. The maximum amount being withheld, I haven't heard that being done. The judgment has been paid, that's not applicable. The garnishment was not properly issued, and I have not heard anything indicating that. or that the balance of the statement is incorrect, and I've not heard that. So it does not appear that any appropriate garnishment dispute has been raised under MCR 3.101K subparagraph 1 and subparagraph 2. So I don't know of any reason why I should grant the request made by the defendants. It appears that the garnishment is appropriate. Ma'am, or both defendants, you may certainly submit a motion for installment payments after this motion is determined on the garnishment. But I've got to tell you that it doesn't appear to me that $10 a month or $25 a month is or would be appropriate given the amount that's due and the fact that Elizabeth is voluntarily limiting her income amounts. Now, I understand why she's doing it, because she wants to remain eligible for certain benefits. But on occasion, sometimes you got to bite the bullet and do what you need to do to pay your debts. So on today's hearing, the installment payment issue is not properly in front of me because there's no written motion. So I'm not going to make a decision on that. I am going to grant deny the objection to the garnishment and indicate that the garnishment may continue until there's a proper motion and further order of the court. Counsel, do you want to submit that?
I will do so. I will do so, Your Honor.
All right, that's all for today then. Thank you.
Thank you.
We do.
Yes. You guys are done. Thank you.
Thank you, Your Honor.
I have another one.